Now, I know a lot of you have very strong opinions about the Lucy Letby possible appeal, and also the conduct of lawyers and the cover-ups in the post office scandal. Well, this is a chance for you to have your say about that. So what am I talking about? I am talking about the Law Commission, and they have put out a public consultation on how appeals work generally. And what I'd like to do is I'd like to go through some of the questions that they're asking, and I'll link in the description to the full report. It's very lengthy, but I'll point some things out that I think you might find very interesting to actually read. So what's this got to do with the sort of like, well, first of all, Lucy Letby. When I did my last video saying about all the waiving privilege, and I've done other videos about the appeals and how she got knocked back on the leave to appeal stage, and people said, well, this is all fine, but this is all really technical. Shouldn't the question just be, is she innocent or guilty? Not has she ticked all the boxes, or did her lawyers approach all the right people? And that is something that is specifically addressed, or they've invited comments on in this consultation. And also with the post office inquiry. I mean, people are saying effectively it's like Watergate. It's not just the crime, it's the cover-up. And only now are we finding out what actually happened. And it's about the interplay between legal proceedings and journalism and transparency and openness. But probably the easiest way to address that is to go through the questions, and when I get to the ones that relate to that, I can just expand. I have notes. That's just my sort of diluted notes. I mean, when you read this thing, it's hundreds of pages long, but it's quite fascinating. But here are the provisional proposals. So they're saying, this is what we're thinking of doing, and then they're saying, but what do you think about that? So first of all, and this is the Letby one, replacing the, quotes, real possibility test used by the Criminal Cases Review Commission when considering whether to refer cases to appeal courts, with one focusing on the CCRC's view of the case rather than requiring it to predict the court's response. Because you may remember I said this will probably fail, because the CCRC will look at this and say, well, even if we think there's something here, the Court of Appeal will knock this back because, there are all these rules about, waiving privilege and all that sort of thing. So the idea is that the CCRC shouldn't anticipate and say, well, there's no point referring it because it'll get knocked back on technical grounds. They should just say, we think there is actually something here. It's almost what we used to call the old lurking doubt test that appeal courts used to use, where it was, we can't quite put our finger on what's wrong with this, but there's a sort of lurking doubt that something's not quite right. And the idea is then that the CCRC would say, we've got a bit of a lurking doubt about this, something just doesn't smell right, we're going to pass it on to you, and we'll let you worry about it, Court of Appeal. Making the CCRC subject to an independent inspectorate, because obviously there was a lot of criticism of the CCRC with the Malkinson thing, the guy who did 19 years for the crime that he demonstrably did not commit. So they're saying, well, maybe there should be some oversight, because at the moment the CCRC pretty much is a law unto itself. Here's an interesting one. Replacing the requirement for wrongly convicted to prove their innocence beyond reasonable doubt to receive compensation, so that those who can prove their innocence on the balance of probabilities will receive compensation. And again, I've covered this before. There's this rather strange thing that if you succeed on appeal after a miscarriage of justice, you don't get compensation unless you can prove beyond reasonable doubt that you did not commit the offence, that you are factually innocent. I mean, totally. So that was a very high threshold. I mean, there's also that thing that they used to also, even if they did compensate you, they'd knock off like your board and lodgings for the time that you were in prison. Because it's like, well, you had no right to be in this prison, so why should the taxpayer pay for it? Pay for your own bed and breakfast. Charming, eh? Simplifying appeals to the High Court on a point of law in summary proceedings by abolishing the case-stated procedure. What's that? Summary proceedings, magistrates' court. Now, as it happens, you actually have an absolute right of appeal from a conviction and indeed a sentence in the magistrates' court, and it goes off to the Crown Court. It's heard by a judge and 2 lay magistrates, and that's what we call a de novo hearing. In other words, unlike most appeals, it starts from scratch. It's not like you have to sort of show that the court got something wrong and made an error so egregious no magistrate could have come to that decision. You just start from scratch. There's also something called case stated, where you say, well, like, they got something procedurally wrong, they misunderstood the law, so they convicted me on the basis of misunderstanding the law. And that's a different thing. You go off to the admin court, and then they would say something like, well, actually, we think they got the law right, so appeal dismissed. Sometimes they theoretically can say they got the law wrong. Applying the correct test based on the facts that they found, we will impose our own decision and acquit you. Usually, though, they will say they got the law wrong, this is what the law actually is, now go back and have a retrial, but applying the law correctly. And the thing with case stated is you actually have to ask the magistrates, because there's no written decisions in magistrates' courts. They just say guilty or not guilty. And you say, well, look, when we were arguing about what the definition of theft was, or fraud, or assault, or something like that, you said this. So we'd like you to set out in writing your reasons for coming to that conclusion. And quite often magistrates will, well, no, we think we got it right, so we're not going to. So then you'd have to go off and judicially review the decision not to give you the reasons. Then you'd get the reasons, then you'd have to go off to the admin court and argue the substantive case. So you can see why maybe they want that a little bit simpler. Giving courts and the CCRC greater powers to investigate claims that a conviction is unsafe due to juror misconduct. Because, you know, the sanctity of the jury room is something we take very seriously. There's a very interesting case where the jurors were sequestered. We don't normally do that, but they put them in a hotel. And it transpired, this was in a Moider case, it transpired that they decided the quickest way to sort this was to use a Ouija board, get in touch with the deceased victim and say who did this. And the Ouija board came back and said, yes, it was the guy in the dock, so they convicted. Now that, subsequently, people found out about that. Now the appeal was allowed on the very technical basis that the decision hadn't been made in the jury room and not all the jurors were present. They'd done it at the hotel and it was just a few of them. And they'd said, like, hey, the Ouija board says he did it, so see you all tomorrow morning. They got into the jury room and said, we checked last night with the Ouija board, he did it, so okay, guilty. The irony is, had they have actually just done that in the jury room, then arguably they wouldn't have been able to appeal it. Because, you know, what goes on in the jury room, it's very hard to investigate. I mean, what people can have with them in jury rooms is quite interesting. It's stuff like, the test is what somebody would normally carry with them. But this test dates back like a really long way, so it's things like a penknife, a magnifying glass, a snuff box. It's all very strange. But the idea is that it should be a little bit more that they can actually ask jurors and say, look, what was going on in the jury room? You know, did somebody express a view? Did somebody lean on somebody else? All that sort of thing. And enabling more appeals to be considered by the Supreme Court by removing the requirement for the Court of Criminal Division or High Court to certify an appeal involves a question of law of general public importance. Because that's a thing with the way the Supreme Court works. I've got to stop calling it the Judicial Committee of the House of Lords. They will, because they control their own docket, they get to choose which cases they take. And it's not just enough that you have an arguable ground of appeal. It has to be a point of general public importance. In other words, it doesn't just affect you personally or a small group of people, it affects everybody. It's a much wider thing. So the trouble there is you might have an individual case of injustice, but they say, well, it was just you that was stitched up. So, you know, we don't really need to consider it because it's not like anybody else got stitched up. So removing that requirement would allow, theoretically, more cases to go to the Court of Appeal. But like I say, that real possibility one is an interesting one, you know, sort of get rid of that and just have because I think, you know, the Lucy Letby thing there, it might well be that the CCRC would just kick it off to the Court of Appeal and say, look, there's a lot of people making a fuss about this, we're not really sure, but you figure it out. So what they're doing is they're asking now, this is what they want you to contribute on, and like I say, I'll put a link in the description so that you can put your consultations in. We've got a month to do this, by the way. We seek views on topics including the core principles that should apply to criminal appeals. I mean, what should be the test? I'm old enough to remember when it was unsafe or unsatisfactory, and then they got rid of the unsatisfactory bit. The argument being, well, they're synonyms and it's a redundancy, so you don't need both words. So, well, why get rid of them? You know, it scans better as a doublet. So if you're saying it doesn't, you know, add anything, why get rid of it? What's the harm? Because unsafe and unsatisfactory arguably are very different things, aren't they? You know, because you could have a conviction that was unsatisfactory and that it was all corruption and, you know, dodgy evidence and sort of inadequate procedure and biased judges and biased jurors, but the guy was actually guilty. But does that mean you've had a fair trial? You know, because, you know, we exclude evidence all the time. that is indicative of guilt. I mean, confessions have to be excluded if you've not sort of done them in compliance with pace. It actually says, notwithstanding the fact that they may be true. So, you know, this isn't a particularly novel idea. Time limit for lodging appeals. I mean, you do have a very strict time limit at the moment. You've got to get your grounds in relatively quickly. And it might well be that in a very complicated case, you need more time to do it. There's also the, well, what if we find new evidence months or years later? I mean, in fairness, you can apply for time limits to be extended, and usually if you pass the test, you know, the 3-part test, you know, there's a good reason for not using the evidence the first time round. Either it wasn't available or you couldn't have found it without, with regular due diligence. It's got to be inherently credible, and it has to be something that probably would make a difference to the decision, not just that it might do. But if you find all that later, usually they will say, and we will extend time. Because, okay, fair enough, this evidence wasn't available, or you had the good reason, so it only makes sense to extend time. But I can see why they're saying it might be a bit more flexible. I mean, like I said, I don't think the time limits thing then necessarily is a particularly big issue at the moment. The law governing the composition and terms of appointment for the Criminal Cases Review Commission commissioners, in other words, how do they actually get the gig? Maybe we should just comment about that. I mean, feel free, stand for it yourselves. Whether the, quote, unduly lenient sentence scheme should be expanded to cover offences such as causing D-word by careless driving and animal cruelty. Guess which one I'm all in favour of there. Yeah, because the unduly lenient provision is where the Attorney General can step in and say that sentence was unduly lenient. Not just that it was a bit lenient or it was quite lenient, it has to be manifestly wrong. But it only applies to certain very serious offences, and they're saying, well, maybe that should be expanded to these other offences. And obviously, I'm quite there on the animal cruelty one, and the running people over, because that's bad too. I mean, I have to say that, I'm somebody who swerves to avoid squirrels. There is that idea, isn't there, in some Native American cultures that when you shuffle off this mortal coil, the rainbow bridge to the afterlife is guarded by every animal you've ever met in your life, you've ever encountered, and it's up to them whether you cross it or not. So I'm hoping that squirrel that, when I went through the hedge, I'm hoping he'll go, hey, he was willing to take one for the team there, but, guys. Whether the provisions allowing for a person who has been previously acquitted to be retried when there is compelling new evidence should be extended to cover non-penetrative SUL offences and certain historical offences not currently covered. Double jeopardy is the idea that you cannot be tried twice for the same crime. We actually call it atravoir acquit or atravoir convict. I mean, sometimes there are exceptions to that. You can be convicted of GBH, and then if the person then actually subsequently does die, they can retry you for murder. But also there's this idea that even if you've been acquitted of certain serious offences, if new evidence comes to light, and it's a bit like the appeal test, that it has to be evidence that wasn't available at the trial and all that sort of thing, then they can actually retry you. I mean, basically, that tends to be only like confessions, and so it's like, I did it and I'm glad I got away with it. You get acquitted and you publish your tell-all book about how you did it, or you're bragging down the pub about how you got away with it. They're saying, well, that's new evidence, so we can try you. So the idea is just to enlarge on that. Now, here's an interesting one. Well, I think it is. And this is the Post Office one. Whether it should be lawful to disclose evidence for the purposes of responsible journalism to reveal a possible miscarriage of justice. So, Post Office inquiry, Post Office scandal. Some evidence was provided, some disclosure by the prosecution to defence for the purposes of an appeal. Now, once that had been used in the appeal, that's in the public domain and you can report on it. But prior to the appeal, the lawyers, the barristers, they released that information to journalists because it revealed a cover-up. It literally was, here's emails saying, yes, we know these people are innocent, but go ahead with it anyway. So they said, this is, our ground of appeal. And they got into bother with that because the argument is, when material is disclosed, it's disclosed, quotes, just for the purposes of the appeal. Now, we never really found out, because a lot of lawyers think that actual test is wrong. It's a case called Nunn. I won't bore you with the details, but it was basically about when you can release evidence that's been, given to you. And like I say, once it's been heard in open court, you can talk about it freely. But the idea is, before you use it in open court, can you let anybody know about it? And people say, well, what's the harm in it? There's no dispute that this evidence exists. If people say it's false or anything, they could arguably have defamation claims and stuff, But why should there be a blanket bar on journalists reporting this material? Now, counsel apologised to the court. They said, OK, we're sorry we did that. We obviously misunderstood the rules. And the judge said, fair enough, apology accepted. So we didn't find anything out about that. But the argument is, actually, there shouldn't be a bar on releasing it. It should be, if we disclose this evidence to you, subject to the usual rules about, not naming people, minors or people under 18, or releasing sort of, sensitive medical information or stuff that's private or commercially sensitive information. Fair enough, that's the regular rules. But the argument is that it should just be the regular rules. If you've got this material, you should be allowed to talk about it. Also, a little minor one, establishing a National Forensic Archive Service to take over responsibility for long-term storage of evidence used in trials. We have this idea of something called a CSI effect now in trials. Because people have seen all these television programmes where they do these amazing forensic investigations with all the latest equipment and the tests, and they get the result back the same day. Jurors now are sort of going, well, where's the forensic evidence? By the way, forensic evidence, it's a misnomer. By definition, all evidence is forensic. We mean scientific evidence, but now even people who should know better call it forensic evidence, so I'm going to join in. But people sort of go, well, there should be all this scientific evidence because we've seen it on telly, and the absence of that means they're innocent. But also, when people say, I'm a SOCO, CSI equivalent, and I do this, and say, oh, well, we all seen it on telly, they're always right, all this technology is amazing. So that's the arguments about it. But there's also just the storage thing. Like I say, unlike on telly, it'll take 6 months to get a result back. And stuff goes missing, and stuff, you lose the chain of custody. And also, with cold cases, it's like, well, we've now got this. Sometimes it works. Just to go on a little diversion. There's a guy called Wearside Jack. He was the Peter Sutcliffe hoaxer. I'm Jack, I see you are still having no luck catching me. And I actually went to a lecture. It was really good. It was about forensic dialect and voice analysis. And these guys are amazing. They were able to sort of tell, where I was from, when I'd moved, level of education, what parts of the country I'd lived in, who I hung around with. It was really, really interesting. But they actually used those tapes, and they said, this guy, and they narrowed it down to a single street. They said, this guy lives on this street. And they also said, oh, by the way, he'll have had this dental work done and his teeth will look like this. And police went round, but when they knocked on his door, he wasn't in and they never went back. Now, years later, they actually caught the guy because he'd sent some letters in, and luckily they'd kept the envelopes, and they were able to do a DNA test on the envelopes, and that's how they found him. But it was just luck that they'd actually kept the envelopes, because a lot of the time stuff like that just goes in a shoebox in a store cupboard somewhere, and as things get moved around over the course of 10 years, 20 years, it all gets lost. So the argument is there should be somewhere that keeps this evidence secure and safe, and also records the chain of custody, because it'd be very easy defence after, oh, we found this evidence after, and it's got your DNA in it. It's like, yeah, well, it's been there for 20 years. Maybe I met somebody in the pub, shook hands with them, turns out their girlfriend works at the forensic science thing, she moved a box. Every contact leaves a trace, as they say when it comes to forensic science. So those are the proposals. Like I say, you've got a month to do it, and they just want to hear the views. Specifically want to hear the views of people with experience of criminal appeals, such as lawyers, academics, or groups with interest in miscarriage of justice, or those who have tried to appeal their conviction or sentence successfully or unsuccessfully, and their families. Now, they do point out they can't get involved in individual cases, so don't sort of say, I think you should look at, this parking ticket that I got, because clearly the camera wasn't there and I was within the bay. They're not going to look at your case. It's got to be, but you could sort of use that as an example and say, I was treated horribly, and I'm not suggesting that you revisit my case, but this is something to take on board as to maybe somebody shouldn't have to go through what I had to go through. But there you go. Like I say, I hope you found that vaguely interesting, vaguely informative, and vaguely accurate. But this is your chance to have a say, and I've noticed a lot of your your comments about, especially the Lucy Letby stuff. People have raised really good points. Now, there is always the thing of, well, I'm sure somebody else will raise those points, so I won't bother. But it's a bit like lots of buildings burn down because everybody assumes somebody else rang 999. So everybody stood there going, did you all call the fire brigade? No, I assumed you did. And actually I had one once where it was really bad because we actually filmed it. And they said, so, sort of going so you just stood there watching it? And it's like, no, we filmed it. It's like, did it not occur to you to call the fire brigade? It's like, well, there were loads of people stood around, we just assumed somebody had. So, you know, this is a real danger. So, yeah, I mean, feel free to stick something in. You don't have to do full reports and everything. You can just put in like a couple of paragraphs or something. But this is your chance to have your say, because I notice in the press a lot of time, oh, all this goes on, what about, you know, why don't the public get a say in this? You do. It's the same with sentencing guidelines and the Sentencing Commission. You know, they do public consultations, but nobody ever bothers writing in. It's only sort of like the nerdy professionals who write in, and perhaps then, you know, the whole point of the criminal justice system is it acts on behalf of society, and you are society, so it's acting on behalf of you, so you need to tell it what to do. But there you go, and I'd be very interested in all your thoughts in the comments about these issues. And like I say, I'll link to the full report, because there's all sorts of fascinating stuff in there, including a lot more detail about that post office inquiry disclosure issue. It's under the bit where it says journalism. There's, like, it's all hyperlinked. So, well, if I can find it, I'm sure you can, because you're a lot smarter than I am.